Secretary of State.
I provided you yesterday as a courtesy with a copy of my oaths of office. My name is on that as well.
They were not certified.
You are attempting to disrupt with asking questions like this.
I am not.
I realize it may very well be related to your claim to be a sovereign citizen and disputing the
claim to be sovereign. That's correct.
Jurisdiction of this court, but these are not questions this court is obligated to answer.
I would like to correct the record and say that I am sovereign.
All right, you believe you're sovereign. The record is corrected. So, Mr. Brooks, we're getting really close for you crossing the line.
Really close to crossing the line,
being removed from the courtroom for continued interruptions. I want you here.
To that, Your Honor.
Mr. Brooks, you haven't let me get in one sentence this morning. It is only, it's 8:57. I want you to be here. Certainly my preference is for you to be here to participate fully, but you do not have the right to disrupt the proper administration. I demand dignity, order, and decorum. You have been provided with the copy of SCR Chapter 62 that lists the responsibilities that myself, the attorneys in this courtroom, the litigants, it even applies, as you can see if you read it, applies to witnesses, jurors, those in attendance. Everyone here has been respectful other than you throughout these proceedings.
I object to that respectfully. I have not been disruptive, and I do not see any paperwork that you just described to be in front
Mr. Brooks,
of you.
I'm going to continue with a finding right now that you have flagrantly disregarded elementary standards of proper conduct. That conduct will not be tolerated. You stating things even in a mild-mannered tone of voice doesn't change the fact that we've had a dozen or more interruptions by you and by you alone. When you don't like the answer I give, even if that's a non-response, you continue to ask the same question over and over. You repeat yourself. You show absolutely no respect for the court, for these proceedings. You have demonstrated in the short, not even 30 minutes that we've been on the record, that you will continue to disrupt. I am going to have the jurors brought in. Again, it is my sincere hope that you follow these simple and basic rules, but the next interruption, you will be removed to the next courtroom.
I do not consent to any paperwork that is not based factually in law. I don't give my consent.
We have the jurors here?
And I will not agree to anything.
Not yet, okay.
So again, with that title, I object respectfully. With that title name that is on your card, since you will not answer the question that I've merely asked of Your Honor numerous times at this point, can that title name please direct the prosecutor to answer whether there are any more charges? Can the title name please direct the prosecutor to answer whether there is assessment for the charges
Mr. Brooks,
in her possession?
No one's going to be answering these questions, okay? I'm not requiring the state to do that. I'm advising you to stop asking those questions. It will be considered an he's interrupted. Take him to the next courtroom. I'll make more findings when he is in the courtroom next door, and I can do that without an interruption.
Agree to a estoppel, and I will move the court again.
Currently, you are not muted. All right, Mr. Brooks. All right, you can mute him. All right, Mr. Brooks, you have been muted so that I can make some appropriate findings here this morning. I understand that you object. Your objection is noted. Your lack of consent is noted. As I indicated earlier, I lost track after about a dozen or so interruptions by Mr. Brooks. He continues to ask questions that I told him I would not answer. And Even though I made a decision not to answer questions, he keeps asking those. From my perspective, they are questions that any sovereign or sovereign citizen tends to ask regarding my name, my oath, jurisdiction, things of that nature. This court, of course, has authority from the Constitution of the state of Wisconsin, the statutes. I've been duly elected twice now by the citizens of Waukesha County to preside over criminal and other cases in the courts of Waukesha County. I fully am aware that Mr. Brooks, as a sovereign, disputes the validity of that, but from my perspective, they are not issues that need to be debated. He raises these issues really just by simple statements. He has never filed an appropriate motion. Motions are governed by state law. Written motions require that the specific relief be requested, that the motion be based on law and fact. I've never gotten anything even close to that from Mr. Brooks. Even if I were to accept an oral motion, which can be proper at times, he has failed to follow the simplest of procedural requirements. He continues to be in the other courtroom. You can see on the monitor, he's standing, he's facing the other direction, he's yelling I can't hear him, but it appears that he is yelling. I muted him because of his interruptions of the court, and I understand he objects. His objection is again once is noted. And because of the disruptions, and based upon the authority in Illinois versus Allen, I also referenced yesterday a persuasive case. It's not at my fingertips. I'll get that for the record. It's the Pennsylvania case that I found to be of persuasive value, where a similar procedure was done. Frankly, what we are providing here in Waukesha County through the use of the technology we have in the courtroom is far superior to what was done in that Pennsylvania case. I have the ability to mute, to unmute. I can see him. He can see the 4 cameras in this courtroom right now. That would be me. It would be the table where I would like him to be seated. That is empty, the prosecution table, and then the witness stand. I am cognizant that the one limitation is the cameras